The courtroom was smaller than I expected. I had imagined over the preceding weeks something formal and imposing, high ceilings, the specific gravity of a room designed to make decisions feel permanent. What I got was a room on the 4th floor of the Fulton County Courthouse that smelled like old carpet and the particular institutional neutrality of government buildings everywhere, with fluorescent lights and a judge's bench that was elevated but not dramatically so, and a gallery with rows of wooden chairs, most of which were empty on that Tuesday morning in November. I sat at the respondent's table. Marcus was at the petitioner's table across the aisle, and he had brought his brother Darnell with him as a support person, and they were talking quietly in the way that men talk when they want to appear relaxed. Marcus was relaxed. He had filed the divorce petition himself without an attorney because he had assessed the situation and concluded that the simplicity of what he understood it to contain did not require one. He had a packet of papers he had organized in a manila folder. He had his phone face up on the table. He had 11 years of knowing me and the certainty that came with that knowing. The judge, the Honorable Cynthia Osai Mensah, came in at 9:12. She settled her papers, put on her glasses, and looked at both tables. She said, "This is the matter of Ake versus Ake, divorce petition filed by the petitioner." She looked at Marcus. She said, "Sir, are you represented by counsel today?" Marcus said, "No, Your Honor." Then she looked at me. Said, "Ma'am, are you represented by counsel today?" Marcus laughed. It was not a loud laugh, not a performance. It was the quiet laugh of a man who finds a question so obviously unnecessary that the laugh is involuntary. I know what that laugh meant because I was married to the man for 11 years and I had heard that laugh before. It was the laugh that said he had already taken the measure of the situation and found it and me to be exactly what he expected. No attorney, of course no attorney. She could barely afford the co-pays on our joint health insurance. What attorney was she going to walk in with? The door behind me opened. My attorney's name is Viviana Sant Botang, and she has been practicing family law in Fulton County for 23 years, and she walked into that courtroom with the specific unhurried authority of a woman who has appeared before every judge in that building and knows exactly where to sit. She set her briefcase on the table beside me. She said at a volume calibrated precisely for the judge to hear without being theatrical, "Good morning, Your Honor." Viviana Sant Botang for the respondent. She removed her coat, she sat down, she opened her briefcase and placed 3 folders on the table in a single fluid motion that took approximately 4 seconds. I did not look at Marcus when Vivienne sat down. I did not need to. My name is Adiz. I am 41 years old, and the story I am about to tell you is the story of a woman who was underestimated so consistently, for so long, by the person who was supposed to know her best, that the underestimation became the most useful thing he ever gave her. I grew up in Accra, Ghana, and came to the United States when I was 14, when my father took a position at Emory University's Department of Economics. I grew up from 14 onward in Atlanta, in the particular experience of a girl who is neither fully from one place nor fully from another, and who learns from that experience to observe carefully and move deliberately, because the world does not hold space for people who have not yet established where they belong and how they operate. I graduated from Georgia State University with a degree in accounting, worked for 4 years at a mid-size Atlanta firm, and then started my own bookkeeping and financial consulting practice for small businesses, which I built over 8 years into something with 11 active clients, 3 of them long-term retainer relationships, generating income that I was careful about, organized about, and entirely separate about from the moment of incorporation. I met Marcus Ake at a community event in 2010. He was charming and he was warm, and he had the specific quality that I have since come to understand as a form of gravitational pull rather than a form of character, the ability to make a room orient toward him, to make the people around him feel that they were the most interesting ones in it. We dated for 2 years. We married in the summer of 2013 at a venue in Buckhead with 112 guests, and a reception that lasted until midnight, and a beginning that felt in every external sense like exactly the beginning I had planned for. I want to tell you about the marriage before I tell you about the divorce, because the divorce is not legible without the marriage, and because I want to be honest about what was real before I am honest about how it ended. Marcus was for the first 4 years a genuinely good partner. He was employed as a regional sales manager for a medical device company which required significant travel and which he managed with the organizational discipline that his professional success depended on. He was affectionate and he was present when he was present, and our life in the house in East Atlanta had a warmth to it that I do not want to revise in retrospect. We built a shared financial life, a joint checking account at Wells Fargo, a Vanguard investment account, a savings account into which we each contributed monthly according to an arrangement we had formalized together in a spreadsheet during our first year of marriage, and which we maintained with the shared commitment of 2 people who believed they were building something together. I want to give those 4 years their full description because they deserve it, and because I have learned from the women I work with that reducing a marriage to its ending is its own kind of dishonesty. We cooked together on Sunday evenings. Not elaborately, Marcus made a specific jollof rice that required 2 hours and a specific ratio of tomato paste to stock that he had learned from his mother, and that he made the way men make things they learned from their mothers, with the combination of precision and pride that I found genuinely endearing for longer than I sometimes admit. I brought the ingredients home on Saturdays from the DeKalb Farmers Market, which required a 40-minute round trip and which I made without complaint because the rice justified it. We ate at the table in the kitchen of the East Atlanta house with the radio on, and those Sunday evenings had a texture that I am describing accurately when I describe it as good. He read to me occasionally, not all the time, not systematically, but there were evenings when he would find something in whatever he was reading that he wanted to share, and he would read it aloud, and I found this quality more intimate than most of what passes for intimacy. We had a shared bookshelf that was genuinely shared, his Chinua Achebe and his Toni Morrison and my Ama Ata Edu and my accounting textbooks coexisting on the same shelves in the way that only happens in houses where both people feel they belong equally. He was generous with my family. When my mother visited from Atlanta, my parents had moved to a smaller house in Marietta after my father's retirement from Emory. Marcus received her with a warmth that was genuine and that I recognized from watching men fail at exactly this quality as something worth appreciating. He remembered her preferences. He asked about her church. He translated sometimes between her and my American-born friends in a way that was neither patronizing nor performative. He was for those 4 years the man I had believed I was marrying. What I am trying to establish before I tell you about how it ended is that the marriage was real. The ending does not revise the beginning. Both things are true and both things matter. I kept my practice separate, not as a hedge against what might happen, as correct business structure. The practice had been incorporated in 2009, 4 years before the marriage, and its accounts, its tax filings, its client contracts, and its operational identity had always been entirely distinct from my personal finances and entirely distinct once I married from our marital finances. This was not a secret. Marcus knew the practice existed and knew it was separate and had never questioned the structure because the structure was normal and he had no reason to question it. What shifted and when and why, I have spent time thinking about this in the specific way that therapists and their clients think about the turning points in relationships, which is to say carefully, and with the awareness that neat causation is usually a retrospective imposition on a more complicated actual sequence. What I can tell you is that by 2017, 4 years into the marriage, the warmth had been replaced by something I did not yet have a name for but that I would later recognize as the particular coldness of a person who has begun in their own mind to be somewhere else. Marcus was less present. He was more critical in the small and consistent way that is harder to name than the dramatic kind, the observation made in the wrong tone, the question with the verdict built into it, the pattern of responses that over time produces in the person receiving them a subtle recalibration of what they are allowed to be confident about. I want to be specific about this because vagueness about what emotional diminishment looks like is part of why it is so difficult to name while you are living inside it. It did not look like fighting. It looked like a Tuesday evening when I described a new client I had brought on and Marcus said with a mildness that was its own commentary, "You really think that's sustainable?" It looked like a Saturday morning when I mentioned that the practice had had its strongest quarter since 2015 and Marcus said, and returned to his phone. It looked like a dinner party in 2018 where I was describing my work to a friend of his and Marcus said, with a lightness that could have been read as affectionate, "She's very optimistic about her little business." I heard the word little, I filed it. I want to be precise about what I mean by filing something because it is different from reacting to it or suppressing it, and the distinction matters. When you file something, you acknowledge it fully and accurately. You do not minimize it, you do not explain it away, you do not immediately contextualize it into acceptability, and you place it in a mental category that is separate from your immediate emotional response to it. You do not let it go, you do not hold it up to the light every day and turn it. You simply know it is there, accurately recorded, and you let time and accumulation reveal what the pattern actually is. I filed the word little in 2018. I filed the sustainable comment in 2017. I filed the him in 2017. I filed a comment he made at a family gathering in 2019 about my commute to the office, the distance, whether it was efficient, that was ostensibly logistical, and that contained underneath the logistics the specific implication that the effort of maintaining an independent office was disproportionate to what the practice produced. I did not say anything about this comment at the time, I noted it. By the end of 2018, the filing cabinet in my mind had enough entries in it that the pattern was legible. He believed my practice was smaller than it was. He had arrived at that belief through years of not taking it seriously, of giving his primary professional attention to his own income and his own career and treating mine as a secondary concern that was optimistic at best. And he had begun from that belief to make practical suggestions about the practice's structure that served his picture of our marriage, one in which his income was the center and mine was a supplement, rather than the actual picture in which my practice was a separately incorporated professional business with its own identity and its own value. I did not correct his picture directly. I let it develop because his picture was not my problem as long as my own documentation was accurate, and my documentation was accurate. He began in 2018 to make financial suggestions that I recognized as something other than helpfulness. He suggested that my practice income should flow through a joint account for ease of management. He suggested that the practice's client retainer agreements should be formalized jointly, as a married couple's shared business, which is what he described it as, which it had never been. He suggested, with the specific casualness of a man who expects to be agreed with, that a joint LLC might be a better structure than my separate incorporation, for tax reasons, which was either uninformed or intentional, and which I discussed with my own accountant, who confirmed that the existing structure was correct and the proposed change would serve no legitimate tax purpose. I did not agree to any of these suggestions. I engaged with them as good faith discussions and concluded them without conceding anything, which required more patience than I have described here, and which produced in Marcus a quality of frustration that he expressed as concern for our shared financial management, and that I understood as something more specific. In 2019, I began to understand that the marriage was ending. Not from a single event, but from the accumulated weight of evidence that a person with a background in accounting processes the way they process any evidence, by recognizing when the pattern is definitive enough to act on. Marcus had begun the particular behavioral signature that I had learned from conversations with women I knew who had been through divorces to recognize as pre-departure preparation. The incremental movement of his personal financial activity away from our joint arrangements, the increased opacity about his professional income, the social repositioning that involves spending less time with shared friends and more time with individual ones. I made my first appointment with Vivienne Asante-Boateng in March of 2019. A colleague had referred her, a woman I had done bookkeeping for who had used Vivienne 3 years earlier. Vivienne had an office in Buckhead that was organized with the precision of someone who has developed, over 23 years, a practice whose quality is visible in every detail of how it operates. She was 61 years old, small, with closely cropped gray hair and reading glasses on a chain around her neck, and she had the quality that the best professionals in any field have. She made complicated situations feel navigable without making them feel simple. Our first meeting lasted 2 hours and produced a clear-eyed inventory of the marriage's financial situation and what the relevant legal considerations were. Vivienne asked about the practice, its structure, its history, its accounts, its valuation. She asked about the joint assets, the house, the Vanguard account, the Wells Fargo checking and savings, the cars. She asked about the history of the marital finances, who had paid what, when, from which account, in what pattern. I answered every question accurately with the documentation I had brought, organized in a folder in the way that an accountant organizes things, which is to say completely and chronologically. Vivienne said, after reviewing the materials, "Your practice is almost certainly separate property. The structure is clean and the separation from marital finances is complete." I said, "I know." She said, "I want you to understand that this is the most important fact in your divorce." I said, "I know that too." She said, "Does Marcus know the practice's value?" I thought about that. I said, "He has an impression of it. He does not know the number." She said, "Let's keep it that way for now. I want to tell you about the 2 years between that first meeting with Vivienne and the Tuesday morning in November, because those 2 years are the substance of what made that morning what it was. What 2 years of preparation looks like in practical terms is this. It looks like a Friday evening in May of 2019, sitting in my home office with the practice's bank statements going back to 2009 spread across the desk, organizing them into a Dropbox folder by year and quarter, a task that took 4 hours, and that I completed with the specific patience of someone who understands that the work being done is important even though it will never be visible until the moment it is needed. It looks like a Saturday morning in July of 2019, meeting with the valuation analyst at his office in Midtown, answering his questions about the practice's client concentration and revenue trajectory and competitive positioning with the precision that 11 years of running the practice had made available to me. It looks like a Tuesday evening in September when the 47-page valuation report arrived in my email, and I read it at my kitchen table with a glass of water and my reading glasses, and felt, in a way I had not been certain I would feel, the specific solidity of something that was real being measured and recorded. It looks like the spreadsheet I built in Google Sheets in the fall of 2019, tracking every marital financial transaction I could access from the joint accounts and the Vanguard account, organized by year and by category, with notes on the pattern and the exceptions. The 18 months in 2018 and 2019 when I had covered more than my proportional share of the mortgage, because Marcus's income from the firm transition had reduced and I had absorbed the difference without making it a confrontation. Each of those transactions was in the Wells Fargo records. I pulled every one and put them in a separate folder labeled simply, Mortgage 2018-2019. Vivienne later described that folder as one of the 3 most useful items in her case file. It looks like the Chase account I opened in October of 2019 at a branch on Ponce de Leon Avenue in my name alone, funded from practice income used for personal expenses that had nothing to do with Marcus. 18 months of statements, a picture of my individual financial capacity, maintained and growing independent of the marital estate. It looks like a Sunday morning in February of 2020 when I called my mother in Marietta and told her what I was doing, not in the detail I am giving you now but in the general form, that I was preparing, that I had an attorney, that I was being careful. My mother was quiet for a long time. Then she said in the Ghanaian English she speaks when she is being direct, "Adiz, you are always going to be all right." I said, "I know, Mama." She said, "I am glad you know." We said nothing else about it, and we have not said anything else about it since. It looks like going to work every day, seeing my 11 clients, managing the practice's operations, filing the quarterly taxes, meeting Vivienne every 6 weeks in her Buckhead office to review the documentation and update the plan, and doing all of this while also being externally a woman whose marriage was deteriorating in ways she was managing with more composure than most people would have given her credit for, because most people did not know what she was building in the spaces around it. There was a specific quality to those 2 years that I find difficult to describe accurately without it sounding either heroic or miserable, and it was neither. It was the quality of a long piece of careful work. The same quality that you bring to any professional task that requires sustained attention over an extended period. The bookkeeping engagement that takes months, the audit that requires working through 5 years of records, the client relationship that builds slowly across 20 small meetings before it becomes something substantial. You do the next thing and then the next thing, and you trust that the accumulation is building towards something that will matter when it is needed. Marcus and I continued to share the East Atlanta house through most of 2020 and into 2021, which meant that the preparation was happening in the same physical space as the marriage's ongoing decline. I did not find this as difficult as I might have expected. The preparation gave me something to do with the energy that would otherwise have gone into managing the anxiety of an uncertain situation, and anxiety managed through action is anxiety that does not consume you. I organized the documents in the evenings after dinner. I updated the spreadsheet on Sunday mornings before Marcus was awake. I reviewed the valuation report quarterly to keep its details current in my mind. I was building a case the way you build any structure, foundation first, then frame, then all the finishing work that makes it habitable. I also began in the second year to plan the forward structure of my professional life. I identified the office space in Decatur that I would eventually lease. I spoke to the 2 independent contractors I was considering bringing into the practice about their interest in a more formal arrangement. I updated the practice's client agreements to reflect terms that were appropriate for a growing business rather than a solo practitioner, which was work I had been meaning to do for 2 years, and which the specificity of the preparation had finally given me the focus to complete. By the time Marcus filed, the practice I was walking into court to protect was not only better documented than it had been in March of 2019, it was better run. This is the thing about preparation that does not get described often enough. It is not only defensive, it is generative. The 2 years I spent preparing for the end of my marriage were also 2 years of building the life that came after it. The documentation and the planning and the careful attention to what was mine did not only protect what existed, it expanded it. The practice that Vivienne characterized as separate property in October of 2022 was worth more than the practice she had valued in April of 2019 because I had spent the intervening years building it rather than managing grief. I commissioned a formal valuation of my practice in April of 2019 from a certified valuation analyst whose firm was in Midtown Atlanta. The process was thorough, 6 weeks, multiple methods including the income approach and the market approach, a review of client contracts and revenue history and the practice's competitive position in its market. The resulting report was 47 pages. The enterprise value of my bookkeeping and financial consulting practice as of the assessment date was $380,000. I had not told Marcus that number. I had not told Marcus that I had commissioned the valuation. I had not told Marcus that I had retained Vivienne. I had not deceived him about any of this. I had simply not disclosed it, which is not the same thing, and which is the legal and ethical position that Vivienne had advised and that I had understood was appropriate. Marcus's impression of my practice, assembled over years of dismissing it as a little business, was substantially below its actual value. That gap between his impression and reality was going to matter. I spent 2019 and the first half of 2020 completing the documentation that Vivienne and I had identified as necessary. Every business account statement organized by quarter going back to the practice's founding, every client contract with the origination dates established, every tax return for the practice filed separately as a Georgia LLC for 11 years. The Vanguard account contribution history, which showed that my contributions had been consistent and equal to Marcus's through 2016, and had subsequently exceeded his as his own contributions had reduced, a pattern Vivienne described as relevant to equitable distribution. The mortgage payment history for the East Atlanta house, including the full year of 2018 during which Marcus's income had been reduced by a firm transition, and I had covered the mortgage from my personal account, documented in bank transfers that were clear and dated. I also, during this period, did something that Vivienne had suggested in our second meeting and that I want to describe specifically because it is the kind of practical preparation that most people do not think about. I opened a personal bank account at a different institution from any account Marcus, and I shared a Chase individual account funded with income from the practice, which I used for personal expenses that were mine alone and which established over 18 months of statements a clear picture of my personal financial capacity independent of the marital estate. This is not hiding money. This is the ordinary financial hygiene of an adult who is preparing to live independently, and the 18 months of statements it produced were part of the picture Vivienne presented in our response to Marcus's petition. Marcus filed the divorce petition in September of 2021. He filed it himself without an attorney. The petition was competent in its basics. It correctly identified the marital property and the grounds for dissolution, but it contained in its asset characterization section the specific evidence of the miscalculation he had been making for years. He valued my practice at $40,000. He listed it as a joint business asset. He had used his own impression of the practice, formed over years of not taking it seriously, as the basis for what he put in a legal document. I called Vivienne when the petition arrived. She said, "I've seen it." I said, "What do you think?" She said, "I think he did not prepare." I said, "No." She said, "Good, come in Thursday and we'll build the response." The response Vivienne filed was 43 pages. It included the 407-page practice valuation, the 11 years of separate business tax filings, the complete contribution history of the Vanguard account, the mortgage payment documentation from 2018, and the 18 months of personal Chase account statements establishing my individual financial capacity. It characterized the practice as separate property with the specificity that only complete documentation makes possible. It addressed every asset Marcus's petition had listed, with accurate values and accurate characterization, and it included a financial disclosure that was more complete than his in every respect, which established from the first document we filed that this respondent had prepared in a way the petitioner had not anticipated. The preliminary hearing was scheduled for November. It was not the final proceeding, it was a scheduling and preliminary matters conference, the kind of hearing where the logistics of the case are established. Vivienne had told me it was unlikely to be definitive on its own. What it was definitively was the first time Marcus and I would be in the same room since the petition arrived, and the first time Marcus would understand that I had an attorney. I want to tell you what the morning of the hearing felt like because it is the part of the story that I return to most often, and because what it felt like is not what I expected it to feel like. I had expected to be nervous. I had spent 2 years preparing for this and I was not prepared to be nervous, but the body does not always consult the preparation. What I felt sitting at the respondent's table in that 4th-floor courtroom in the Fulton County Courthouse was a stillness that I did not recognize immediately and then recognized as the stillness that comes from being exactly where you have been working toward. Not come exactly, I was aware of my heartbeat and the particular scratchiness of the courtroom air and the sound of Darnell whispering something to Marcus at the other table, but still, the way a tree is still in a wind, rooted rather than rigid. I had dressed carefully. This sounds like a small detail and is not. I wore a navy suit I had purchased at Ann Taylor 3 weeks earlier with a cream blouse and the pearl earrings my mother had given me when I passed my accounting certification exam in 2006. I had pressed the suit the evening before. I had been deliberate about this in the same way I had been deliberate about everything in the preceding 2 years, not from vanity but from the understanding that the way you present yourself in a room that is making assessments about you is part of the preparation, and that I had not spent 2 years preparing to walk into that room in anything less than my full presentation. Vivienne arrived at 9:11. She came through the courtroom door with the specific unhurried pace of a woman who is never late and never rushes, which are different qualities that only look the same from the outside. She wore a dark charcoal suit and carried a briefcase that I knew contained 3 folders organized in the order she would need them. She nodded at the judge's clerk, who nodded back in the way that courtroom clerks nod at attorneys they have seen many times. She sat beside me, she placed the folders. She was entirely settled in approximately 4 seconds, and Marcus laughed. I heard it. I do not think Vivienne heard it, or if she did, she gave it nothing, which is its own form of response. The judge looked over her glasses at Marcus for a moment and then returned to her papers. And then the hearing began, and the hearing was what hearings at that stage are: procedural, organized, a series of scheduling matters and preliminary characterizations and the first formal exchange of positions. Vivienne spoke 3 times. Each time she was precise and documented and entirely unflappable. Marcus spoke twice. The second time his voice had lost the quality it had when he laughed. The hearing established the schedule for the full proceedings. It also established in the specific and undramatic way that legal proceedings establish things the complete difference between the 2 parties' levels of preparation. Marcus's petition had valued my practice at $40,000. Vivienne had filed documents valuing it at $380,000. The judge did not rule on this at the preliminary hearing. She did not need to. She noted the discrepancy. The discrepancy was the story. The proceedings took 11 months. Marcus hired an attorney after the preliminary hearing, which was the correct decision and which he made approximately 2 years later than would have been useful to him. The attorney was competent. The problem was not the attorney. The problem was that the foundational positions established in Vivienne's response filing, the positions built on 2 years of complete documentation, were not positions that a competent attorney retained in October 2021 could substantially dislodge in the discovery process, because the documentation that supported them was complete and dated and unambiguous. You cannot retroactively dispute 11 years of separate business tax filings. You cannot retroactively challenge a valuation conducted in April 2019 before the petition was filed by a certified analyst with a 47-page report. The preparation had a timestamp, and the timestamp was the argument. The settlement was reached in October of 2022. The practice was characterized as separate property and was not divided. Its value was acknowledged at the assessed figure. The house equity was divided equitably with an adjustment that reflected the 2018 mortgage contribution history. The Vanguard account was divided based on the contribution analysis Vivienne had prepared. Marcus received what was fair, I retained what was mine. I want to describe the day the settlement was signed because the day itself has a texture that matters and that I do not want to compress into a summary. It was a Thursday in October. Atlanta in October has a particular quality of light, lower than summer, more considered, the kind that makes even the ordinary look like it was lit deliberately. I drove to Vivienne's office in Buckhead, parked in the same garage I had parked in for 3 years of meetings, took the elevator to the 11th floor. Vivienne was at her desk when I arrived. She had the documents organized in the order they would be signed. She offered me water. I said yes. We went through the settlement line by line, which took 40 minutes because Vivienne goes through settlements line by line with her clients regardless of how fully they have been prepared, because a decision that is made completely is made once. I had no questions that I had not already asked across the preceding months. The documents reflected what the documents were supposed to reflect. I signed, Vivienne witnessed. The opposing documents had already been signed by Marcus and his attorney and were waiting in Vivienne's folder. Vivienne set the folder on the corner of her desk and removed her reading glasses from the chain around her neck and said, "It's done." I sat with that for a moment. Then I said, "How do you feel about it?" She said, "I feel that you were the most prepared client I have worked with in 23 years. I said, "The preparation was available to me." She said, "Most people don't use it." I drove home through October Atlanta with the radio on. I stopped at the Whole Foods on Ponce de Leon Avenue and bought the ingredients for the jollof rice that Marcus used to make on Sunday evenings, which I had learned to make myself across the preceding 2 years, not well at first, and better over time, the way you get better at things you practice with patience. I cooked it that evening in the kitchen of the Ormwood Park house, which I had been living in for 8 months by then, and I ate it at the kitchen table with the ficus plant visible through the doorway to the living room, the same ficus that I had carried in a cloth bag from the East Atlanta house, which had survived the move without incident and was, if anything, thriving in the north-facing window of the new house in a way it had not always thrived in the old one. I called my mother after dinner. Answered on the second ring. I told her it was done. She said, "Good." She said, "Are you eating?" I said, "I just made the jollof." She said, and I could hear the specific quality of her smile. "Good girl. I want to tell you what I know now that I did not know before I began this, because knowing it might shorten the distance between where you are and where you need to be. The first thing is about the laugh, not Marcus's laugh specifically, the dynamic it represented, which is the assumption of disproportion. Marcus laughed because he had built, over years of not taking my practice seriously, a picture of me as someone who would come to that courtroom without preparation, without resources, without the professional backing that the situation required. That picture was assembled from years of being called optimistic and little and unsustainable and all the other words that people use when they have decided the thing in front of them is smaller than it is. The laugh was the expression of that picture. The door opening behind me was the correction. If someone in your life has been using dismissive language about what you have built, the little business, the hobby, the side thing, I want you to understand that the dismissal tells you something important about their calculation of your position and that their calculation is not the same as your position. Know the difference between those two things, it is everything. The second thing is about the valuation, and I want to say this as directly as I can because it is the most practically important thing in this story for anyone who owns a professional practice or a small business. If your practice is incorporated separately with its own accounts, its own tax filings, its own operational history distinct from your marital finances, it may be characterizable as separate property in a divorce proceeding. But it needs to be valued. Not by your own estimate and not by your spouse's impression, by a certified professional whose methodology is documented and whose report is dated. I had my practice valued in April of 2019, more than 2 years before Marcus filed. That date mattered enormously. A valuation completed after the petition is filed is defensible but not optimal. A valuation completed before, as part of preparation rather than reaction, establishes a baseline that is independent of the adversarial context. Get the valuation before you need it. The cost is manageable. The alternative is having your life's work valued by someone who called it a little business. The third thing is about representation, and I want to address it specifically because I know that the cost of a family law attorney is the reason many women walk into courtrooms the way Marcus expected me to walk into that courtroom, unprepared, unrepresented, negotiating from a position they do not understand against a position they cannot fully see. Vivienne was not inexpensive. I had saved for 18 months specifically for the retainer from practice income that I had been careful not to commingle with marital funds. I had budgeted for this the way I budget for any significant professional expense, as an investment with a calculable return. The return in my case was the difference between the $40,000 Marcus's petition had allocated to my practice and the $380,000 it was worth. The math is available to anyone who wants to do it. Find the attorney, pay the retainer. Understand that what you spend on preparation is not a cost, it is the investment that determines what you keep. The fourth thing is the one that I think is most important and least discussed, and it is about the gap between what someone believes about your situation and what your situation actually is. Marcus's entire strategy was built on an impression of me that had been assembled from years of being told my work was smaller than it was. That impression was the only picture he had. He did not have the valuation report. He did not have the 11 years of separate business filings. He did not have Vivienne. He had his impression and he had filed a petition based on it and he had laughed in a courtroom based on it. The gap between his picture and the actual picture was the gap that the preparation existed to protect. This is the thing I want you to carry with you. The picture other people have of your situation is not your situation. The picture your spouse has of what you have built is not what you have built. The number in someone else's head is not the number in the valuation report. Your job is to know the real number, document the real number, protect the real number, and to let other people's pictures of your situation remain their problem rather than yours, right up until the moment when the door opens and the picture changes. I run my practice from an office in Decatur now 3 days a week in person and 2 remotely. The 11 clients I had when Marcus filed have become 14. The practice revenue last year was the highest in its 12-year history. I bought a small house in Ormwood Park 8 months after the settlement alone with a down payment from the Vanguard distribution, and in the living room there's a ficus plant I have had since 2014 and which I carried from the East Atlanta house in a cloth bag in the back of my car because there was no version of leaving that house in which I left without that plant. Vivienne sent me a note when the settlement was finalized. It was a card handwritten from her office in Buckhead. It said, "You were the most prepared client I have worked with in 23 years. The preparation was the case. I keep the card in the top drawer of my desk at the Decatur office in the same drawer where I keep the practice's founding documents from 2009, which is where it belongs. The laugh was a gift. I have thought about this many times." The laugh told me exactly what he believed about me, exactly how he had calculated the situation, and exactly how far his calculation was from the reality. You cannot prepare to correct a miscalculation you do not know exists. The laugh told me the miscalculation. The 2 years of preparation were the correction. And when the door opened behind me and Viviana Sant-Boteng set her briefcase on the table and said, "Good morning, Your Honor," in that voice calibrated for a room that was already paying attention, that was simply the moment when the correction became visible. He had 11 years to understand what I had built. He used them to decide it was small. That was his choice and it was generous of him, and I am still grateful for it.